Also, I'll start with you. What were the biggest takeaways from this afternoon's and now this evening's judgment?
I think it is a judgment that has put the BBI process on complete halt. It has shaken the proponents and the supporters of BBI. It has shaken the country. A very incisive and elaborate judgment that has dealt with more than 20 issues and systematically dismantled the process and also the content of the BBI amendment.
All right, Kennedy says he has a question for you. Kennedy, go right ahead.
Well, Mr. Kanjama, we've seen what has happened, and it has been happening since 4 o'clock. But now the question that begs is there any recourse probably for the way forward with the promoters of the BBI having been dealt such a blow when it comes to the ruling that has just been given?
There is always a recourse for those who are dissatisfied with a court decision. The High Court is the court of first instance in dealing with constitutional questions of this magnitude. There is a constitutional process in which a party can seek to appeal to the Court of Appeal on constitutional questions, and if still dissatisfied, to do a further appeal to the Supreme Court. However, you must note that the BBI process was being rushed with what I would call indecent haste because there were very limited timelines to get the whole process done and prepare for the 2022 general election. That process of appeal is likely to take time, and it means that even if BBI still has some hope, if a higher court overturns a decision of the High Court, the current timetable for BBI is basically dead in the water.
Well, Kanjama, probably by that admission that you're making, is it true? Because there is also have been some arguments that have been made with regards to the timelines. Is there a probability that this particular BBI process can be held beyond August, or is it that
Sorry,
it cannot...
I didn't get your last question.
My question is, with regards to this BBI process, does it really have timelines? Some have argued that they can actually do it even past August. Is it a possibility, and are we also looking at a possibility of them pushing it forward and also pushing the 2022 elections?
Okay, so the current constitution establishes that fundamental changes to the electoral structure, like constituencies and so on, cannot be done less than 12 months before the general election. The BBI process was trying to short-circuit this by shortening the period through an amendment. The High Court has found that those attempts are unconstitutional in and of themselves. So the question of whether that process can go ahead is one that will be determined by the Court of Appeal, but it looks unlikely because the timelines are really tight. And even the proponents of BBI had admitted that they want to have the referendum latest by July, so that what IBC needs to do can be done before the 2022 election. IBC, as you recall, issued a statement or memorandum to Parliament during parliamentary debate on the BBI amendment bill, in which they said they need generally 12 to 18 months to do some of those substantial changes they were being asked to do within 3 to 6 months.
All right, Charles, can you kindly break down what the issues basically break down the determination as to the issues that were up for determination? I heard them talk about IBC, the signature verification process, registration. So what were these issues that they decided on?
The first issues that the court decided on were issues of what you call the essential structure doctrine. Does the Constitution have a fundamental essential structure that cannot be amended through the normal methods of amendment of the Constitution? Or is every provision in the Constitution equally subject to the amendment process? And this was in the constitutional petition that was filed by David D. and Jerotich Say. And the High Court held that there are certain provisions in the Constitution, including in Article 89 of the Constitution, that cannot be amended by just the ordinary amendment process. The court actually defined what would be the special process for amending some of those provisions, including having a constituent assembly. They said those are primary constitutional provisions, including what they're calling the basic structure of the Constitution. So that was the first set of questions that were dealt with. The second set of questions were questions to do with the process that had been followed in coming up with the BBI, right from whether the president could initiate a popular initiative, whether the popular initiative was a government project, whether the collection of signatures was done properly, whether Kenyans were given enough time to review the bill, to verify the signatures, whether IBC was properly constituted, whether the process stages, whether they were done in accordance with the law. And systematically, one by one, blow by blow, the court found that the process of BBI was severely wanting on constitutional grounds and declared the BBI process completely unconstitutional, fraudulent even, and went ahead to find that the president had even violated the Constitution. He had breached Chapter 6, and that would mean if the decision stands that the president himself is susceptible to be impeached on a finding of a court of law. The third set of issues was on whether some of the constitutional amendments, substantive questions, were themselves violating other provisions of the Constitution. And here the court was looking at what you could call amendment by infection. You are purporting to amend one provision of the Constitution, and effectively you are amending another provision of the Constitution. And the court did find that some of the amendments in the Constitution to do with the structure of parliament, the number of constituencies, and so on, were amending other provisions indirectly, and those were also struck down. Finally, number 4, the court considered what would be the way forward, assuming the BBI process was restarted in the proper way, and you went to a referendum. What would be the requirement for that BBI bill or for any amendment bill under popular initiative to pass the test? And the court found that you'd need multiple referendum questions so that you do not sugarcoat poison pills within a package of constitutional amendments, and you allow freedom to Kenyans to vote on each of the specific provisions or distinct areas of a constitutional amendment bill. So those generally were the 4 areas that the court dealt with.
Well, thank you very much, Mr. Kanjama. But then there's the question that begs, and probably 2 more questions before I leave it to my colleague Olive. And this is the question: can this bill be reintroduced in Parliament and considered through a parliamentary process? That is one of the questions. And question number 2 is with regards to what has been going on and what we have learned so far with regards to the BBI. Now, this question of President Uhuru Kenyatta even being found to have faulted Chapter 6 of the Constitution. As you say, they have been insisting that they now have a super number. 235 is beyond the 233 that is required in Parliament. Is there a possibility that they could use this numerical strength in Parliament to just overturn some of these things when they introduce this bill? And is there any time if this bill is introduced in Parliament?
Okay, so those are several questions, and I'll answer them as best I can. Number 1, there is no restriction to the process of amending the Constitution restarting again, and I think the court established guidelines that can be followed, and that process can begin again either as a popular initiative or as a parliamentary initiative. Number 2, there are certain procedural hurdles that will be crossed or surmounted if the process was to start again, including the quorum of IBC, including the need to have a referendum law in place before the process begins again. Number 3, including the fact that for a parliamentary process, it's clearly defined that you need 90 clear days between the first and the second reading of a constitutional amendment bill. you need substantial public participation. The court said that you need to restart the process of voter registration and give Kenyans a fresh chance to register before a new referendum. Of course, including the fact that if there was a new process starting in parliament, the threshold for parliamentary approval is 2/3. And you would say that parliament already has shown they will approve by more than 2/3. But that was assuming that it was a popular initiative backed by 5 million signatures. If it starts in parliament alone, there's going to be the possibility of amendment of the bill, which the court said is not possible in the case of a popular initiative. Finally, if the bill was brought to parliament, some of the provisions in the bill have already been declared to be going against the basic structure doctrine and would therefore fall by the wayside. So the very same BBI package bill, even if it was initiated in parliament, would still fall afoul of several of the findings of this High Court, unless it was a much more trimmed down version of the BBI bill, focusing on only a few provisions, those provisions that require a referendum under the entrenched provisions of the Constitution would still need to go for referendum.
Well, Kanjama, probably the last question from me before we do go for a break is there's some by-elections that we've held as a country since the other commissioners probably resigned and went into other matters. Now, what is the fate of such by-elections, and could somebody probably go to court now that it has been ruled that the IEBC is not properly constituted? They say that it needs 5. Does anybody have the loci standi of going to court and probably saying that these by-elections were not conducted properly and we want them nullified?
Let me start by saying that there is precedent in court decisions when the Ethics and Anti-Corruption Commission was not properly constituted and they made decisions to charge people in criminal courts. Several of those decisions were later overturned when the court found that a lack of quorum in the commission significantly or fatally hampers the ability to make certain decisions. So there is precedent for that. However, anyone who wants to go to court to challenge election outcomes that were conducted by an inquirite IEBC would face several challenges. One is a rigid constitutional timeline found in the Constitution that you must lodge the election petition within a certain period of time, normally within 1 month after the end of the election. So if you've not lodged the election petition within that time, you cannot now go to court and get a hearing. But if you had already lodged a petition and you're already going through the court process, then the question arises, can you amend your petition? And there have been several cases that for filing petitions. So that means that those who are elected are safe, unless it is someone who was declared elected recently. I think this happened in the case of Garissa Senate. That might be the only one that faces a threat of being overturned.
What about the other two that are just about to be held probably next week? This is in Juja and also the other constituency in Kisii County.
Okay, that's a very good question. So you're asking now to anticipate the future matters that involve IEBC.
Yes.
Based on the decision of this court, it is possible that the losers in those cases will go to court and raise the question of an inquirite IEBC. But I do feel that there's always a defense to that argument, and the defense is what the Supreme Court has previously termed the doctrine of necessity. If there are constitutional timelines for carrying out by-elections and IEBC is inquirite, then the doctrine of necessity could come in to save those who have got into office, electoral office, in that process. So the doctrine of necessity would apply based on my analysis of other judgments of the Supreme Court.
And perhaps I can close out this conversation by asking you, as an advocate, Charles, how do you feel as an advocate following to this evening's judgment?
Let me say that having listened keenly to several parts of the judgment, as an advocate, it's not possible for me to agree with each and every sentence or finding of the court. That's impossible. I have my own independent judgment and views. But as a general view or perspective of the decision of the court, it is an extremely courageous decision. There has been a lot of concern about manipulation of the Constitution, disintegration of the Constitution through a rushed political process. And I think what the High Court has done is they have put down a very strong marker that the judiciary is not a political branch of government. They will give a cold, analytical response when requested by Kenyans to political questions. And I could summarize the philosophy of the judges in this Latin expression, fiat justitia ruat caelum. Let justice be done, though the heavens fall. That's what the judges have done. And I think they have shown, they have demonstrated a willingness to try to be competent, to try to apply the law as they see it, to try to be firm, and also in their attempt to extend the application of Chapter 6 of the Constitution, and even to show that the president himself has to be subject, not just in theory, but in reality, to Chapter 6, and even to court cases that are founded on Chapter 6 or founded on violation of the Constitution. I think what the judges are saying is that enough is enough to the politicians. To the line of the Constitution, the dreams, the spirit, and the values of the Constitution, the text and the context of the Constitution, or get out of the kitchen.
All right, thank you so very much, Charles. Thank you, Kennedy. I see you picked up quite a few terms. Loci standing, was it? Well, a lot to digest there, so let's take a break.